So today we're going to talk about actually e-commerce and cybercrime associated with it. So I've been looking at the facet, let's start with this whole concept of e-commerce as such. When you look at today's world, the kind of internet audience which is there, which is growing tremendous. You got something like around, say, 6 billion of individuals who have access to internet. Okay. So, and basically, when we are talking about access to internet, we are talking about high-speed internet, which basically encourages business to innovate, and there is an array of online services. And when I talk about this, I talk about COVID-19. I now actually put my whole existence into two brackets. Life before COVID and life after COVID. Life before COVID was something, it was kind of a hybrid, which I can say that most of the things which we were dealing with society or businesses at large were mainly in terms of analog and digital. But when you look at the facet, just actually the kind of, prevalence of coronavirus and, the whole lockdown situation which transpired in this country and all over the world for a matter of fact. And you suddenly has this impetus of, being online. So, it's thanks to coronavirus, you now actually are insisting even groceries. It's basically moved into the fast lane and you have most of the things now which is online. So when you look at the most powerful trends on internet, which now actually it's more relevant to are the smartphones and also like the kind of entertainment which we are actually consuming, the kind of movies, music, whether it's companies like Netflix or any kind of TV programming which we have, so which entails streaming services. And as well as now when you talk about technology or softwares as such, now they are software as a service. They are no more actually kind of those or what do you call it, softwares with those shrink wrap agreements in place. So the standoff winner in e-commerce, most of the big players, which you call big tech. So where sales have just phenomenally soared because and thanks to coronavirus. And some of them are having exclusive things like free shipping if you're some kind of exclusive members of those big tech companies. So basically, when you look at this scenario about pre and post COVID, you will have this kind of timeline where this whole concept of e-commerce has evolved. So when we look at this facet, you look at 1970s. So internet was like a series of communication protocols which was written by Vinton Cerf. And basically when you talk about this, you're talking about DARPA, and DARPA is Defense Advanced Research Projects Agency, and most of the internet protocols and things which we see right now in its phase has been devised during the 70s and especially by DARPA. So a well-enabled internet was rolled out, and you have this phase in which actually HTML, which was there, which was in 1989, which was done by Tim Berners-Lee, and you have this hyperlinked cyber world where we were actually exclusively sharing. And when you talk about 1989, I don't think so. Actually, most of us were, or most of you were even born, for a matter of fact. And we were not really, India as a country was not really actually connected to the world at large. It was only post 90s when we started actually, having this kind of concept in which BSNL came into foray, and you have this kind of scenario in which 94, 95 was a pivotal year in which actually we started connecting to the world at large. And it was mainly text-based email and things like that. So it was not really the impetus of e-commerce, or when you talk about EDI, electronic data interchange, all these things were not actually, there. It is only after when you look at this whole situation post 90s, after the dot-com bubble bust, that you see this has really actually taken impetus. So when you talk about capitalization from this, new internet-enabled companies, where they basically, some of them were really cash-strapped, companies which were started in garages. When I look at 90s as such, I can only think about, two kinds of things which came out of garages. One was the grunge bands which were there, bands like Nirvana, Pearl Jam from Seattle, and another thing was actually, those internet companies which started, multiplying as such. You had Netscape, you had PayPal, and all these things actually started proliferating, during that period of time. It was 90s. But unfortunately, I mean, when you look at 90s, I'm talking about a post 94 situation. Okay. So you had like, tremendous amount of money being pushed in by venture capitalists, and and there was the Netscape IPO which was there. But unfortunately, I mean, during the 2000, I mean, it was the kind of a bust era in which actually uh, the Nasdaq tumbled, and most of the entrepreneurs during that period of time found it very, very difficult to raise funds. So post the dot-com bubble burst, it was 2003, 2004. And 2004 was actually pivotal year for online e-commerce companies like Amazon. It was actually, this was the time in which actually broadband as such started proliferating. And you had this excellent concept of, I mean, in a sense, you could do e-banking and things like that. And this is where it really, all kinds of consumers started actually, looking out for bargains, and you could start and post 2000, you could start actually downloading music, you started watching videos. And I mean, this was just actually low cost that really fueled this steady growth, global growth of e-commerce companies. And it was whether it was inexpensive devices, computer prices had fallen down. And I mean, this was just actually years in which actually technology really proliferated, and and it really started picking up, post 2010. And when you look at 2019, this was the year, a pivotal year in which actually most of the companies, when you look at even India, for a matter of fact, they just got impetus because of this. So you have all these Zomato, or when you talk about US, you talk about Uber Eats, or you talk about Flipkart, and most of the companies. I'm sorry, actually, I shouldn't be taking names of them. I'm not actually, trying to promote any e-commerce companies as such. So you had this retailers which were there. You had this B2B kind of concept, B2C concept, business to business, business to consumer, business to administration. Even India, for a matter of fact, I mean, the kind of things in which actually your interaction with the government actually changed. The whole facet changed and it's all thanks to e-commerce. So when you look at this whole concept of banking, also it really actually transpired. It changed the whole facet. So uh, several factors encourage this. Most of the consumers to do the shopping online, and it's mainly it is the kind of adoption of high speed internet access. So when you look at India, I think so the rollout of 4G. I can actually divide this kind of thing in which actually you had most of the things which were done actually using a desktop or a laptop computer prior to actually 2008, 2007, I think so. And later on, actually, you started actually having these devices, mobile devices, which were actually, GPRS enabled, and you had this, 3G, which came into foray, especially with telecommunication, and 4G, and now you have 5G. So this whole facet of broadband internet penetration is just tremendous. And when you look at this whole concept of, now when you look at e-commerce, you have this concept of package and food delivery by drone. Unfortunately, in India, still the use of drone is restricted because of certain regulations. So you have Wi-Fi, you have, this kind of fiber optic, which is actually now down to your home and connected with various devices, Internet of Things, and and fiber to home, cloud computing, software as a service. And and when you look at India, uh, it's a new commerce battleground when you look at the kind of population which we have and the rollout of 4G, which I've already mentioned. And in India, unfortunately, actually, when you look at this whole kind of e-commerce segment, which you're talking about, commercial segment, it's still, e-commerce, when you look at it's only 5% of the total value which is there. I mean, what online uh, rollout is just there. I mean, it only accounts for 5% of the total retail sales in India compared to the 14% global coverage which is there in the world. So when you look at e-commerce now, suddenly most of the, I mean, this is kind of, this era is pre-COVID era, which I'm talking about, and post-COVID. So now governments have really started actually looking at this kind of concept in which actually they have started becoming more and more parochial. They've started actually becoming more and more insular, where they think that, having certain trade barriers in place, you would actually, give more impetus to the local players which are there in the foray of e-commerce. So unfortunately, actually, some of the rules and regulations which have come down of lately, 2021, gives this kind of impetus to insular trading mechanisms in place. So how do you actually look at this whole facet of, e-commerce as such, that how it is, gone about, and, how it is related to, let's say, for example, cybercrime, and how they are interconnected. When you look at commerce as such, so the kind of phenomenal growth of e-commerce in India is just, is just astounding. And the rising dependence on internet commerce now, the kind of fraud and security and trust problems have become, severe impediments. And that itself, calls for a very robust legal and regulatory framework. And that should address the concerns about, this online fraud, data security, and intellectual property issues, whether in a local or business, international business context, and that I'm pretty sure that you've been reading a lot of instances in newspapers, kind of fraud which is being generated, whether it's online banking, whether it's OTP, and, things like that, parcel delivery frauds, and also in terms of investment frauds which are taking place. So like electronic commerce, just like any expanding business, it has to confront various obstacles. And this is primarily because of its inefficient legal and regulatory framework. Especially when you look at a country like India, you have this single kind of act which was devised at one point in time for desktop computing, which is not actually up to the mark of what transpired later on in the 21st century. So you're still actually, it's a work in progress. So you basically have a framework that is, it does not guarantee the rights and duties of all players, and especially when it comes to user data, or tackling certain cyber threats, or maintaining customer trust. So all these companies which are operating in this segment have to, have tremendous compliance. So when you look at India, the cybersecurity framework or the governance falls under this act, Information Technology Act of 2000. So it regulates e-commerce, electronic contracts, data protection, cyber crimes. So basically, what does information technology addresses? It addresses unauthorized access, hacking, identity thefts, phishing, computer virus dissemination, and it's got certain what do you call it? Rather, I would use the term what the objectives, basically when it was enacted. And it was enacted in the backdrop of a global recognition for the exposition of a cyber regulatory framework, and that was done by UNICITRAL, that is United Nations Commission of International Trade Law, and that was in the year 1996. And I keep on reiterating, this was a law which was done way back, and it was an adoption of a model of e-commerce to bring about uniformity among the countries of the global, cyber regulation framework. So it elaborates on data privacy with the growth of internet, the data of people that are online. So basically, it has a lot of kind of a hybrid system in place, which basically aims, and what does actually Information Technology Act aim? So it basically grants legal recognition to e-commerce, and basically it grants certain safety or safeguards to transactions which are carried out by either by electronic data interchange or any other means of electronic means of communication. So it also recognizes, the bankers' electronic forms. So the book of accounts maintained by the bankers have always been, a kind of a source of evidence, and the kind of scrutiny which demands, for the banks to be answerable to if any kind of transactions when they go wrong. So also it has, what it has done is it has amended certain provisions in the Indian Penal Code, in the Indian Evidence Act, and the Bankers Book, and the Reserve Bank of India has also actually amended certain provisions. So Information Technology Act is also has recognized this concept of e-evidence in a in the court, so it makes access to justice easier. So these are the kind of things. It recognizes documents filed with the government. So e-governance is a major pivotal which is there. It's a great kind of impetus for citizens at large to deal with the government. And it recognizes data storage, electronic data storage, and especially when you look at this concept of DigiLocker now, you don't require to actually produce your original documents, in a sense. I mean, if you have these documents, whether it's in terms of your, Aadhaar card or voter ID card or PAN card and driving licenses. So this was another, thing which has been done under the broad framework of this Information Technology Act. So, and it almost also talks about, electronic fund transfers, whether it's, between banks and financial institutions, and this rapid, growth of internet banking or mobile banking, which you say. So this is very important when you look at the objectives of, so of Information Technology Act, and it's mainly to actually push and regulate and to have this broad umbrella framework for protecting and safeguarding electronic commerce. Okay, so when you look at what types of electronic commerce we are talking about, so what are the classifications? So when you talk about, you hear this kind of things about what B2B, B2C, so business to business. So it's basically what electronic transactions, I mean, basically of good and sales that are conducted between two companies. Okay. So, and when you talk about business to consumer, consumer to consumer, when you talk about consumer to consumer, you're talking about auction sites like, eBay or OLX for a matter of fact. So, and there is a concept of consumer to business actually, where consumers are certain times actually, when you consumer to business, I can give you one example is actually when you do certain creation. Content creation, like, maybe actually come down with reels on Instagram or things. It's basically consumer to business actually, because that's the whole business model of most of the big tech companies when it comes to social media, because you are the content creators. And when you are the content creators, you are actually, basically dealing with big tech platforms. You're devising or you're making content for them. So, I mean, basically it's consumer to business. So C2B and business to administration. So, I mean, it's basically, kind of in which small companies are actually dealing with, government at large. And you're talking about consumer to business administration. I'm sorry. And this is like, I mean, it's basically talks about public administration, when you talk about taxation, health, all these things are actually, part of this classification of what kind of different e-commerce uh, companies are dealings with within e-commerce. So the basic classification. So what basically, when you talk about what actually are the important things which are, issues in global e-commerce which needs to be understood. So the legal aspects of e-commerce, as I've already mentioned, this has been a model legislation which has come down, and has been accepted by the United Nations. And but so whenever there is a, kind of this model code which is actually devised, certain kinds of standards or issues or cultural aspects which are there in a particular country are not really addressed. So when you talk about e-security is another aspect in which, it's a grave concern. So this is another thing which is, it is very easier for any individual who sits in any particular area of the globe to actually, break certain standards, or, actually hack into a computer, or or commit certain financial impropriety by breaching certain data secure servers. And especially when it comes to jurisdiction, I mean, it's a whole globe. So you don't even know actually, if you're using virtual private networks, you don't even know actually whether it says India, whether it's India, I don't know, I mean, some other country maybe. And especially when it comes to contracts and the liability, I mean, so e-contracts now have been given legal recognition, and liabilities as such are also enforceable. Um, But when you talk about when you're talking about this, when you're talking about different nations, I mean, the jurisdiction becomes a huge problem. Another aspect which comes to actually is taxation. This is another area, gray area. When you're talking about taxation, you're also talking about money laundering. You're talking about, place of residence of a taxation, determining the origin of income, and especially when it comes to jurisdiction, tax status. So all these things are actually, kind of what do you call it? Advantages and disadvantages. So when you look at advantages when it comes to e-commerce, I mean, especially it is 24/7. The kind of geographical distance or time is no more an issue. The cost of sale, scale is actually economies of scale actually changes the whole facets when it comes to e-commerce, because you can cater to the world at large. And it's cheaper doing business online. Actually, you don't require hard infrastructure in place. So and it takes less delivery time as such. And especially when it comes to cost, it becomes a huge advantage. Only thing is actually when it comes to e-commerce, the regulatory framework is a major problem as such when it comes to e-commerce. So again, I'll come down to the thing of Information Technology Act, which which is what you call it, the umbrella framework, which I always say that I use that word. So through this act, the Indian government is enforcing cyber security standards, whether it's in terms of enterprises, organizations. It talks about standards which needs to be maintained in the IT infrastructure and the kind of incident response mechanism which has to be there in place. So overall, when you put it in a nutshell, past decade, especially, I mean, post-COVID, tremendous rise or a surge in electronic commerce, the prevalence of smartphones, cheaper internet data plans, increasing data literacy. Millions of Indians have now turned to, the online platforms, whether it's in terms of shopping, banking, or any other services. So online marketplaces have really, transformed your shopping habits. I mean, it has. Previously, it used to be, consumption. It used to be, I mean, kind of cable television. Now you have different streaming services which are offering you very different kind of content, or kind of music, the kind of genres which you can hear right now, the kind of magazines which you have access to, which is just tremendous. So it's a broad range of products and services. So it is not only has it actually given you a huge choice, but it has also increased competition among businesses which are offering this kind of goods and services via internet. So there is another aspect is actually, the kind of collaborations which are now really taking place, whether it's between corporations or corporations and individuals. I also highlighted the stuff in which actually you yourself now you have become a content creator. So the global e-commerce, sector has grown just substantially, and e-marketing, electronic funds transfer, inventory management systems, online transaction processing. So the e-commerce ecosystem, when you talk about it not only has entities like the government, it also has, transportation companies, including Indian Rails, airlines, roadways, merchants, manufacturers, and content providers. So these companies, along with ISPs, call centers, shipping companies, financial intermediaries, and social media sites, they're facilitating online transactions. Okay. So this is in short, actually, and when you talk about safeguarding e-commerce, you're also talking about, vulnerabilities in e-commerce platforms. So you're talking about, breaches as such of sensitive personal and financial information, or when you're talking about, you are an easy target for cyber criminals, and whether it's in terms of breaches which can lead to certain data theft, financial fraud, identity theft is another area. So you have payment system frauds which are proliferating. You have counterfeit products and fraudulent sellers. This is another in which actually, if most of the tech platforms are not actually having a due diligence mechanism in place, you'll have a lot of counterfeit goods which are actually sold on those platforms. So another aspect is data breaches, and this is just actually The new act, which is going to come down, actually, the Digital Data Protection Act will address that. Unfortunately, the rules have not been formulated, and so it's not in place. So you are actually still actually looking at this kind of system in place, which is still actually the old Information Technology Act and its rules, which are still applicable at present. So basically, when you're talking about electronic commerce, you have this Information Technology Act 2000, and you also have the Consumer Protection Act 2019 with this with e-commerce rules 2020. But only problem is actually the coordination between law enforcement agencies. That remains a huge challenge. And another facet which comes to mind is actually, you don't even require to be hacker in place today in today's world. Last time I actually talked about crackers, or I talked about darknet. Now you have this kind of tools and mechanisms which are available. Cybercrime as a service. So I mean, if you're basically, I don't know actually how relevant you are with Tor network or the dark web, you have this whole array of tools and people who are actually kind of I mean, you can outsource certain nefarious activities, basically illegal acts. That's another area which is actually that's another thing is ransomware. This another thing actually which comes to fore is actually most of the businesses, when they are hacked or the servers are hacked or something or the other, they charge a ransom for actually giving you the control back of your website or your e-commerce companies. And the kind of cyber awareness which is there, and or digital awareness which is there in a country like India is just unbelievable. It's just I mean, we call ourselves quite educated, but when it comes to cyber awareness, we are absolutely ridiculously, unaware of things. I have this classic concept in which I say that, I mean, we have this thing in which we consider the device to be the safe haven. When you are there in your house, you think actually that physical security guarantees you a digital security. Unfortunately, it doesn't work out that way. If you don't have firewalls, if you don't have a basic understanding about how networking or systems work, how things are, it's very difficult actually. The kind of things which you share with other people at large is also another problem area, which people don't realize that. If I as an individual, if I wanted to share certain information at large to any stranger, I would be very, very circumspect. But here you are at world at large, on maybe on Facebook or maybe on your any other social media platform. You're just actually discussing and sharing things, your photographs, your things, I mean, just phenomenal. I mean, the kind of things, just by having your single phone number and, or your email ID, and you can actually, construct the whole identity framework of an individual in today's world is just phenomenal. So people are not really that smart, actually, what needs to be posted, what doesn't need to be posted. So it's just phenomenal. So, when you talk about role of Information Technology Act, and especially when it comes to combating cybercrime and safeguarding, in a nutshell, it talks about legal recognition of electronic documents. It talks about electronic filing of documents. It talks about digital signatures, data protection and privacy. I think so. Somebody called S. Jane has raised a hand. Could you kindly actually? I have no idea what is he trying to say something?
Yes, I just had a question. Yes, so the thing was, like you spoke of B2B online marketplaces.
Yeah.
So let's say from a seller's perspective,
Yeah.
especially when we in our IT Act, when we have certain safe harbor provisions for intermediaries.
Intermediaries at large. Yeah.
Yeah, right. So, what exactly should a seller look at or negotiate from such intermediaries? To what extent those terms should be? Because especially when we have a safe harbor clauses for intermediaries protecting them. So, and especially when they have a standard set of terms and condition in place. So, how do a seller negotiate its terms
Oh,
from
but
an intermediary?
are you talking about
Yeah.
seller as an intermediary? You're talking about platforms are basically an intermediary, right? So when you enter
Yes.
into a contract, you enter into a contract with a platform, right? I mean, it can be irrespective of which platform it will be, right? if
Correct, sir.
I'm not mistaken. So basically, you have Consumer Protection Act 2019, and you also have the e-commerce rules which are there in place actually. When you talk about goods, okay. So I will highlight about intermediaries, and I'll explain the concept of that. But as seller, you will have to actually agree to the terms and conditions of what is there on the platform. If you are not actually conversant, if you feel there are different platforms which are there, and every different platform will be having different terms and conditions for you to become a seller, right?
Exactly, sir. But and especially when because they are selling as is on as is basis, right? They're providing service on as is basis.
Yeah,
So we
marketplace,
technically
marketplace. Yeah,
yes, so definitely we do not have a say to negotiate the contract. So what how bad is it?
yeah.
Or if we at all we
Unfortunately,
are to negotiate, then
yeah.
yeah,
See, that's the problem with the big tech. Okay, so I mean, these are kind of ethical issues which are there. I mean, in terms of a small player, how do you actually have a leverage when you're actually dealing and negotiating a contract? That's your question.
correct, sir. Yeah,
Yeah, and I mean, I'll address that in the end, but I do understand it's an ethical issue. It's not actually in terms of it can be addressed by a legal mechanism. Okay, so that's more or less actually dealing with the Competition Commission. So we are talking about basically digital signatures. We are talking about data protection privacy. We are talking about cybercrime offenses and penalties, and also about regulation of intermediaries. We'll come down to that later. So I'll address this question also at the same time. So rather than actually digress from what we've been discussing. So anyway, there are a lot of issues at large, and please understand one thing: within this kind of paucity of time, it is not possible. I try to do as much as possible to actually compress whatever things are there, but unfortunately, it cannot be compressed within the time framework of 1 hour or something. It really needs a lot of time to actually address each and every nuances of cyber law, whether it's in e-commerce or intellectual property rights and things like that. It's not possible to do it. But anyway, it's just a mere, what I can call it is actually, surf, basically, you can only, you can't deep dive into this thing, you can only do a surface level swimming, you can do out there. So anyway, so promotion of secure electronic transactions and certain cyber security measures. Okay, so this is basically what we'll be talking about. So when we talk about legal recognition of electronic documents, this is the most important thing in which when you talk about safeguarding e-commerce, the first and foremost thing is the recognition of electronic documents. So this is a pivotal aspect of facilitating e-commerce and streamlining the administrative process. So when you talk about IT Act, it confers a legal validity and enforceability to electronic documents and records. So basically, that means that electronic contracts, agreements, invoices, and other forms of electronic documentation are treated with the same legal significance as their paper-based counterparts. So parties, when they're entering into electronic transactions, can rely on electronic documents as evidence in legal proceedings. Okay. So the other aspect is which is digital signatures. And this is, basically, when you talk about digital signatures, you're talking about authenticating electronic documents and transactions. Okay. So digital signatures are nothing but cryptographic techniques that verify the identity of the signer and ensure the integrity of the document. And basically what it does, it provides an assurance that the document has not been altered, tampered with since it was digitally signed. So thus enhancing trust and confidence in electronic transactions. So basically when you look at commerce, the most important thing is trust and confidence. So especially when you're looking at electronic commerce where you don't have this kind of facility in which you are able to inspect goods as such. So this is the kind of trust and mechanism which we are talking about. If you don't have trust and confidence building measures in those kind of transactions which are taking place, it's going to be very difficult for any person to conduct business online. Okay, so it's going to be very difficult to enter into transactions. And another aspect when it comes to is electronic filing and submission. So this is another thing in which actually documents, whether it's government agency, regulatory bodies, you're talking about, stock exchanges, you're talking about income tax, you're talking about, company regulation mechanisms in place. So all these things actually, it requires electronic filing and submissions. So instead of having this kind of paper-based, traditional paper-based processes, you have certain things in which you can submit documents online and it can be accessed anytime and from anywhere. And you have certain standards and guidelines which are there in place. So the government does actually, prescribes certain standards, guidelines, and procedures for the authentication and verification of electronic documents. There are certification authorities to actually, certify digital certificates. So basically, certificate authorities, they are responsible for verifying the identity of individuals, entities applying for digital certificates. And so digital certificates, they serve as electronic credentials that validate the authenticity of digital certificates, signatures, and electronic documents. Another aspect is record keeping and retention. So the information technology law also has provisions for maintenance, retention, and storage of electronic records and documents. It specifies requirements for the preservation of electronic records in a manner that ensures integrity, authenticity, and accessibility over time. So, in a nutshell, legal recognition of electronic documents is one of the most critical aspects of information technology law. So, it basically it essentially provides a legal framework for electronic transactions, communication, and record. So, when you look at this aspect, one needs to highlight basically what exactly is electronic contracts. So when you look at what entails electronic contracts, so when you talk about electronic contracts, again, that thing comes to mind is actually contract law 1872. So section 2H. So it tells about that contract is basically an agreement that is enforceable under the law. So basically, when you talk about electronic contracts, it is still actually, a contract which comes into existence, but basically it's online. So it's an e-contract is nothing but an agreement that is enforceable under law and in all its respects drafted, negotiated, and executed digitally. So e-contracts are basically entirely digital. So there is no what do you call it, meetings, physical meetings, but the meeting of minds has to be there. That's fundamental. So when you look at e-contracts, it also comes down to the validity of an e-contract. So when you talk about e-contract, Section 10 of the Indian Contracts Act 1872 and Section 10A of the Information Technology Act, it provides a crucial prerequisites for a contract to be legally valid. So basically, a contract has to satisfy all the prerequisites of the Contract Act. So whether it is terms of who is entitled to contract, enter into an agreement, the offer, the acceptance to offer, consensus, lawful consideration. So all the elements have to be there when you talk about. So basically, 10A of the Information Technology Act 2000, it basically talks about validity of contracts formulated through an electronic medium. So basically, it's an online thing. It's an electronic means in which actually the formation, the communication of proposals, acceptance of proposals, revocation of proposals, and even acceptances are expressed in electronic form or by means of an electronic record, and which is basically a contract, and it shall not be deemed to be unenforceable solely on the grounds that such electronic forms or means was used for that purpose. So this is, when an agreement meets all the essentials conditions of a contracts, so e-contracts are enforceable by law and considered to be valid contracts. So when it comes to contracts, again, the thing comes to mind is evidence. So contracts as evidence. So Section 65B of the Evidence Act 1872 talks about it, and it also actually that any information that is contained in an electronic record that is either printed or on a paper, stored, recorded, or copied in an optical or magnetic media produced by a computer is deemed to be a document when the conditions mentioned in the sections are satisfied. So what are the kinds of contracts which are there, e-contracts which we are talking about? So different amalgamations. I talked about shrink wrap agreements. You talked about click wrap agreements, browse wrap agreements, scroll wrap agreements, sign in wrap agreements. So basically, shrink wrap agreements are end user license agreements. Basically, so it's basically software, which I doubted now you have those kind of box softwares which are there, and which actually when you tear out that package, and basically you are agreeing to those terms and conditions. So when you talk about click wrap agreements, is again actually when it's I agree kind of thing when you click it in the end, or when you talk about Google Forms when you're submitting it. So that's another thing. So when you use or click I agree, you are basically it's a click wrap agreement. Browser wrap agreements is again when it comes to online contracts and license agreements, you actually there's basically no procedure as such, but when you scroll down or when you double click on certain terms and conditions, it will be basically termed as a browse wrap, or you can actually have this concept of scroll wrap agreements, and sign in wrap agreements, and also electronic signatures, which we'll get into detail later on actually as we progress. So when you talk about Section 4, actually, of the uh, Information Technology Act, it talks about uh, legal recognition of electronic records. So if any law requires information or any other matter to be in writing or in a typewritten or printed form, then the requirement is deemed to be fulfilled if such matter is rendered or made available in an electronic form. Okay, accessible so as to be usable for a subsequent reference. You also have this concept of electronic signatures. So any subscriber may authenticate an electronic record by affixing his digital signature. Section 5 talks about it. So it talks about authentication of an electronic record, and the rules under the Information Technology Act 2000. So Information Technology Certifying Rules 2000. It lays down the procedures and requirements for certifying authorities responsible for issuing digital certificates. So these further recognition of Information Technology Certifying Authority Regulations 2001, it further details the functions, duties, and responsibilities of certifying authorities, including their licensing and whether audit and security measures. So when you condense the whole aspect of legal recognition of electronic records, signature, digital signatures, making them equivalent to a traditional paper-based records and signatures. So authentication can be done by way of electronic signatures or digital signatures, and attribution. An electronic record is attributed to an originator, and alterations must reflect the original intention of the parties. And also, we talked about certifying authorities. So basically, this combination of Section 4, Section 5, along with the associated rules and regulations, forms the backbone of legal recognition for electronic documents in India, facilitating electronic transactions and communications in various domains. So, okay. So the next thing which comes to fore is electronic filing of documents. So especially electronic filing of documents, when you talk about you talk about authorities actually, I mean, mainly filing electronic document filing of documents. It is what it has done is actually, it has made the concept of administrative processing by enabling the submission, storage, and retrieval of documents very easy. Um, Especially when it comes to convenience or efficiency. Individuals or businesses at large, they can submit documents, forms, applications, returns to government agencies, regulatory bodies, and courts through electronic means. Maybe and this pretty um, you have your IT returns which you're filing actually, which is done online. You have this uh, most of your taxation, or whether it's GST returns, or whether it's things, if most of your interaction with government authorities right now online is made easy prior to those electronic filing. So it's basically eliminated the need for physical paperwork, and it has reduced processing time, and it has enhanced the overall efficiency in administrative procedures. So basically, paperless transactions, so basically good for the environment, so-called good for the environment. I don't know, actually. Everybody nowadays actually does this kind of hybrid thing in which actually do transactions online, but you still take out a printout. So the consumption of paper ink, I don't know, actually. I mean, it's debatable. So anyway, another facet which comes to is 24 into 7 availability and accessibility. This is another thing in which actually you can access those, documents. You can review those documents. You can actually alter, amend those documents, and it can be done 24 into 7, most of it, and you can do it online through various devices. And so accessibility of all the stakeholders, whether they are individual businesses who can view, process, and response to submissions as just in a timely manner. And this is very important. So it doesn't matter whether you're sitting in Delhi or whether you're sitting in UK or US, you can still actually, access documents and you can submit them online. And it's a streamlined process. So, so basically, online processes or online filing is much more streamlined when it comes to actually, you have a lot of this kind of, where there are dual choices. So it becomes very, very easy to file documents. So, and especially when it comes to security and data protection, there are certain, confidentiality, integrity, and authenticity of electronic documents and transactions, which is protected under the Information Technology Act. Also, there are certain rules and regulations which are there with regard to encryption, digital signatures, secure lines of communication, protocols to safeguard sensitive information. All these things are actually, some are rudimentary addressed by this umbrella framework, which is there. Of course, I mean, it's still a work in progress, and there are a lot of issues and facets which are going to change. I think so. The act will soon be replaced by a digital act. That's another thing which is there in the foray. Till then, actually, you still have to, continue with the same old act, as I said, and compliance and legal validity. So electronic filing platforms comply with legal and regulatory requirements for document submissions and retention, ensuring the legal validity and enforceability of electronic transactions. So the IT Act, basically it recognizes electronic documents and digital signatures. So there are numerous benefits actually, efficiency, convenience, accessibility, security, compliance. So it basically transforms this whole administrative process and the interaction with the government. So there is digitization of document workflows, it reduces paperwork, so transferability, accountability in governance, screenshots, acknowledgement receipts, all these things which are there. So it becomes pretty simple when you are doing it. So electronic filing of documents is basically an essential part in the legal framework of Information Technology Act. So when we talk about this process of electronic filing, it's basically your preparation of documents. You basically sign those documents by digital signature. You submit those documents. You have an acknowledgement in place, which is there. And then there's a concept of processing, which is there, and communication. So application status, which is there, you can have ready accessibility to it, and the final disposition, which is there. Anyone who has actually dealt with kind of e-filing processes which are there, you would know what I'm talking about. And most of us have been doing it, whether it's in terms of actually getting even admissions in colleges nowadays is online. So I mean, you have instant access to it. You have instant, I mean the payment mechanisms, the things, whether it's accepted, rejected, you don't have to wait for a long period of time. So what it is, I mean basically what does it help? It helps in terms of efficiency, it helps in terms of cost savings. So electronic filing, and also in terms of transparency, because it provides real-time status updates, and that is you're tracking your applications. Even in terms of your basically courier service, actually, you can track those packages 24/7. And accessibility, as I said, and of course, I mean, so-called disputable thing about electronic environmentally, whether it's friendly or not, that's something which is there, because as Indians, we still actually have this kind of dual hybrid mechanisms in place, in which actually not only do you file your things online, but you also take out a printout. I don't know actually. So when you talk about electronic filings, you're talking about income tax filings. You're talking about company incorporation, which is done, GST returns, and employees provident fund, which is actually so. So basically, this whole, as I said, it streamlines the process of administrative process, enhances accessibility, it promotes efficiency and transparency in interactions between citizens, businesses, and government authorities. So, and the information technology delivery services rules are applicable out here. And so the combination of, Section 6, along with the associated rules and regulations, establishes the legal framework for electronic filing of documents in India. So it enables efficient and secure submission of records to government agencies and other authorities. So anyway, so this is in short actually coming to the concept of filing, and the most important concept which we come down is digital signatures. And when I talk about digital signatures, I also talk about actually, cryptography. So that's another thing which will come down to. So basically, what are digital signatures? So digital signatures are defined under the Information Technology Act. They are basically cryptographic techniques used to authenticate electronic documents and transactions. Okay. So cryptography, I would recommend a movie called Imitation Game. I think so. The actor is Benedict Cumberbatch, and it's written. The movie is based on a book by Alan Turing. It's an autobiographical book, and the author is Andrew Hodges of that book. I would recommend that movie actually to look at this whole, Alan Turing as such as a crypto analyst. Crypto analyst is a person who's actually basically tries to break certain codes which are part of cryptography. Okay, so what are digital signatures? So digital signatures are basically they are cryptographic techniques used to authenticate electronic documents and transactions. So when you talk about digital signatures, it provides authenticity and integrity. So it authenticates the identity of the signer of a document, of an electronic document, and ensures the integrity of the electronic document or message. So basically, electronic or cryptographic algorithms, they are basically what? They're a unique digital fingerprint or hash value. Uh, I would have loved to actually delve deeper into this aspect of cryptography and digital signatures, but unfortunately, paucity of time, and it's also a kind of a technological subject which I don't know most of us would be conversant or would be happy about doing. But I can take a session on cryptography and digital documents, and also about digital forensics, which we can take it later on and maybe some other day. But anyway, so when I want to condense this whole aspect of it, so it is basically nothing but a cryptographic algorithm. So it basically creates a unique digital fingerprint, or as I said, a hash value of the document's contents. So the fingerprint is then encrypted using the signer's private key. So it has got a dual, a private and a public key, generating the digital signature. So it's asymmetric cryptographic method. Okay. So the recipients can verify the authenticity and integrity of the document by decrypting it, the digital signature, using the signer's public key and comparing it with the hash value of the original document. So what exactly it is? It's a plain text which you are actually converting it into a cipher text, and your cipher text is actually by signing it with your digital private key, and you are actually putting it word at large, and somebody else receives that document, coded cipher document, and he has to decrypt it. So he uses the public key to decrypt it, and he can read the message. So what happens is, when you do it by way of a digital signature, there is a question of non-repudiation. So when you talk about this non-repudiation, it means the signer cannot later on deny having signed the document. So digital signatures are unique. They are signed to the signer's private key, and any attempt to basically tamper with the document or forge the signature would result in an invalid signature during verification because of a hash value. I would have loved to actually dwell into the subject very deeper, but I can just say this much, that whenever you actually use a cipher algorithm, you basically actually what you do is actually it produces a unique key, and that key, the moment you actually alter even a single character into the thing, it can actually change the whole result. The cipher result would be changed. So you will immediately come to know that your document has been tampered with. So basically, the IT Act recognizes digital signatures as legally binding equivalents of handwritten signatures for electronic transactions, and it has certain standards and procedures in place, and certification authorities. The IT Act has established a framework, of certification authorities, which are entities. Basically, they're entities entrusted with the task of issuing digital certificates to individuals and organizations. So these digital certificates serve as electronic credentials that link the signer's identity to their public key, and basically certified authorities play a very crucial role in verifying the identity of certificate applicants using digital certificates and maintaining the integrity of the public key infrastructure ecosystem. Then there are certain standards and guidelines which are there in place. So In short, Information Technology Act, it provides a very secure and legally recognized mechanism for authenticating electronic documents and transactions. So they offer authentication, integrity, and non-repudiation and legal validity, making them indispensable for electronic commerce contracts and administrative processes in India. And through a process established by the IT Act, digital signatures, they play a very pivotal role in, promoting trust, transparency, and efficiency in a digital uh, economy. So basically, as I said, digital signatures, they are cryptographic algorithms. So there is a key generation, and it is done by a way of a pair of cryptographic key. One is a private key, one is a public key. We could delve into this subject much more deeper and how do you sign it and verify it. But basically, in a sense, the concept of digital signature is there under the Information Technology Act. The certifying authorities certify the legitimacy of the digital signatures, the key pair, that is a private and the public key at large. So basically you cannot tamper with those things, and the certification ensures the validity of the private key and the public key. Okay, so basically Section 3 and Section 5 and Section 35, basically deals with those. Section 3 recognizes electronic records. Section 5 actually provides legal recognition to electronic signatures. And Section 35 specifies the issuance of digital signature certificates by certifying authorities. So when you're looking at this whole facet of digital signatures, so what does it uses of digital signatures? Online digital signatures. So they're basically used for what? They're used for signing contracts and other legally binding documents, government services, corporate filings, e-tendering and e-procurement processes. So this is, in short, the benefits might be in terms of security, convenience, cost savings, legal validity. So in a sense, the whole facet is given protection under the Information Technology Act. Another facet which comes to is data protection privacy. I think so. I have mentioned in the previous lecture about data protection laws in India. So you can only come down to the concept of what basically entails data protection, and data is a huge subject actually, which comes into the foray. So basically, citizens or as consumers, we need to have a means to exercise the right to privacy and to protect ourselves from the information, abuse which takes place online. So whether it's in terms of personal information or whether it's in terms of actually, most of the facets which are there, which need safeguarding. And this is basically, it's data protection is our fundamental right. And this has been actually addressed in the KT Puddaswamy case. So under Article 21, it's the right to privacy is actually fundamental, and it talks about, and based on that particular judgment, there was a need for a new data protection law, which is going to be there. Unfortunately, the rules have not been formulated yet, so I don't know actually when the government is going to come down with the notification with the elections in place. I don't know. So maybe down the line, actually, it will be notified, and yes, you will have this new data protection in place. So when we talk about data protection, we talk about sensitive data, personal data protections, whether it is in terms of password, financial information, whether it is in terms of bank account, debit cards information. It talks about your physical physiology or mental health, even your sexual orientation or maybe your medical records, biometric information, and especially it also talks about this processing of such kind of data, and storage of that data. So it's a whole gamut which is there. Actually, it's a sensitive personal data. So data protection is, basically it's commonly defined as a law designed to protect your personal information. So basically, which is collected, processed, and stored either by an automated means or intended to be part of a filing system. So even when you are actually sharing data with the government, it needs to be protected. So when you look at this whole concept, this kind of modern society which is there, and especially the digital society. So it needs to empower us actually, to basically control our own information and to protect us from abusers. So how would you like actually if your medical records are leaked and, or maybe your biometric information which is leaked, or your bank account information. And it's just actually the possibility of this happening in today's online world because of certain social engineering. I'm not talking about in terms of access or unauthorized access or anything of that sort, but it's just tremendous. I mean, there's too much of data, there's too much of information which is floating around. So there is a chance and there is a thing about actually, this kind of things happening. And when you have state actors which are, replacing this kind of romanticized hackers which were there during the 90s and the 80s, it's very, very, a different gamut which we are talking about. So as I said, I mean, the Digital Protection Act 2023, which has been formulated. So still we are looking at this old act, which is Information Technology Act. So the IT rules 2011 actually is still applicable. Reasonable security practice and procedures of sensitive personal data and information rules 2011 is still applicable. Unfortunately, uh, the Data Protection Act should have been, formulated way back, but it's not been done. So Information Technology Act addresses data protection and privacy concerns through various sections and provisions. So Section 43A talks about compensation to failure to protect data. 72A is punishment for disclosure of information in breach of lawful contract. There is 66AE, which talks about punishment for violation of privacy. It deals with the punishment for violation of privacy, and it talks about captures or publishes or transmits images of private areas of any person. So this is voyeurism or whatever you talk about, this kind of things which are happening in today's society, unfortunately, is just there. So I mean, violation of privacy, especially when it comes to, it's very, very important. Breach of confidentiality and privacy, Section 72 addresses that. It deals with the punishment for breach of privacy and confidentiality. It states, any person who is in breach of lawful contract discloses information obtained in the course of duty shall be punishable with imprisonment or fine or both. When you look at the offenses and penalties, it's maximum actually it's up to 3 years, and fines up to actually, I think so. Most of it is 5 lakhs, and some of them actually, when you do it up to 10 lakhs, leaving certain offenses like cyber terrorism. It's got thing for life, and some of them actually, when you do it for the second time, it's for publishing certain sexually explicit images or something. It's there. If you do it for a second time, it's for a period of 7 years. Otherwise, it talks about maximum is actually 3 years, and 5 lakhs is the standard fine which is there. So also Section 69 is spot, intercept, monitor, or decrypt information. So government, this is another area which is there actually. When we talk about state actors, we talk about non-state actors, we also have to talk about our government, which is really interested in controlling the information flow. I talked about this, and there's another movie which comes to mind is Sneakers. Kindly watch this movie. This is very important because it talks about information flow. So a lot of companies, whether it's big tech companies, government, or whether it's non-state actors, everybody is interested in actually, controlling information. So, and that's very pivotal. And whoever is controlling information controls the narrative. It sets the narratives. And information is key. And this is for the first time in the history of human existence that so much of information. I mean, Google knows much more about me than any other person, I presume. Actually, it knows about my likes, my dislikes. It knows about what kind of music actually I like, what kind of movies I prefer. Tech platforms, they have certain, data sharing agreements in place. You don't know. It's just phenomenal when you're online and the kind of information which is floating around. It's very difficult actually. If it was somebody who was a stranger and you tried to share information with him, you would just deny that. But unfortunately, because of your certain behavioral things, and when you click, every click gives away certain aspects of your individuality on the net. So governments are another thing actually, when they really actually are bothered and concerned about individuals at large. I will not actually delve into this kind of thing in which whether uh, really governments actually try to, if you're maybe a political dissident, if you are somebody who's not in favor of the government, or you have certain things which are not in align with the social, political, economic framework which is there existing, and you are huge critic, the government at large would be interested. I'm not saying that it is, would be interested in actually, accessing the kind of information. So that's another. So the power to intercept, monitor, or decrypt information. So again, it comes to actually within the interest of sovereignty, integrity of India, defense of India, security of the state, friend relations of foreign states, blah, blah, blah. So, and Section 79, which talks about, exemptions from liability of intermediaries, certain types of content which has been posted or transmitted through the platforms. And basically intermediaries do have to comply with due diligence requirements, and they have to observe certain guidelines prescribed by the government. So basically, when you look at this whole concept of data protection law, I will not delve into the concept of data protection 2023 because I don't think so. It's still actually there, and this itself would take the whole, act, which is time, which is there, and unfortunately, there is a huge paucity of time, and it's not possible for me to actually, delve into this concept of data protection in detail. So another aspect which comes to mind is this is cybercrime, and this is very important when it comes to safeguarding. And this is the kind of everybody knows what hacking is. So cybercrime, it basically refers to criminal activities that are carried out using digital technologies on the internet. So it is basically illicit activities which exploit vulnerabilities in computer systems, networks, online platforms, and types of cybercrime: hacking, malware attacks, phishing, identity theft, business email compromises. So I'm not going to dwell into details of each of them. Distributed denial of service attacks, and most of you are aware of that. So botnet attacks, cyber stalking, which is not actually really addressing the kind of e-commerce things which are there, but still actually it's a cyber crime. So harassment over internet, cyberbullying, cyber extortion, cyber terrorism, uh, pornography, child pornography, online frauds, cyberbullying is, and data breaches, and basically what is the motivation? Certain, I mean, hackers, yes, unauthorized access, they have certain, just because it's there, they can crack it. That's another anyway. So basically, when it comes to normal individuals at large, it always boils down to financial gain. It comes to espionage when it comes to state-sponsored, non-state sponsored attacks, espionage, corporate espionage. Another thing which comes to mind is ideology or hacktivism. This is another problem which is there. Cyber attacks are done to either, promote a political or social agenda, or to protest against perceived injustice. Revenge is another facet which comes to mind. Actually, a lot of individuals who have certain acts to grind against other people or organizations. I mean, you never know. Thrill seeking is another thing, is with hacking is related to thrill seeking. Same thing is with base jumping, or maybe snowboarding or skydiving, things like that. So hacking is one of those facets in which actually it's a thrill seeking mechanism or attention seeking mechanism. So what are the impacts of cybercrime, especially when it comes to e-commerce? It's financial losses, it's data breaches, which leads to huge privacy violations, and it leads to theft of data, and just disruption of services, essential services, especially when it comes to power grids, transportation networks, healthcare systems in place, and causing huge economic disruptions, and inconvenience to large. Just imagine actually if your payment systems at large were actually under attack, and what would happen actually if you had to do an immediate payment systems, and you had to make a payment, and what would happen if your servers are not functioning? It's just unbelievable. Damages to reputation. This is another thing. Actually, it leads to loss of trust, and this is very important. Once you lose trust, it becomes very difficult to actually do online transactions. So this is very pivotal actually. And the kind of psychological and emotional impact. I mean, how many times would you actually trust a particular company when you ordered something, you got something else, and you suffered loss? I doubt it actually the next time you're going to place an order again. So that's another thing which. So when you talk about aspects in which the impact of cybercrime, and how do you address those things, you talk about strengthening cybersecurity, and this is again when it comes to it, firewalls, anti-software encryption, so, and multi-factor authentication, and I mean, basically it can protect you from certain cyber threats. So, and legislation, of course, I mean, you have this Information Technology Act, not the best of the act, but still that's the only thing which is there at present. So I mean, the umbrella framework which is there, and you have to, I mean, as I said, down the line it's going to be a different facet. So cybercrime legislation, international cooperation is another thing, especially when it comes to jurisdiction, and comes to India cybersecurity awareness. This is where, and this is just awareness is the main facet which is very important. Uh, and India needs it actually. When you have this kind of, you do not have this digitally literate society, you need this kind of cyber awareness, and you need a kind of a capacity building measure in which you have this kind of skilled workforce which develops innovative cyber security solutions. So, IT Information Technology Act has this tremendous array of key offenses, and unauthorized access or hacking, data theft, 43A, identity theft, section 66C, cyber terrorism, sending offensive messages, obscene content, and interception of communication, section 69. So these are some of the facets actually, because each one of them would, and again, every time I actually do this, I always have this paucity of time, and I tend to get carried away, and it really creates a problem for me. Anyway, so next, when we come down to is regulation of intermediaries. Now, this is one question which I think so somebody had addressed, and I had to continue with the lecture, unfortunately, so I could not do justice to it. So when you talk about intermediaries, I mean, what facet are we really talking about? So it's a broad term, I mean, when you talk about intermediaries, it's a very broad term. As I said, I mean, it's under section 2(1)(w) of the Information Technology Act, and it defines intermediary as a person who receives, stores, or transmits any electronic record and provides and provides any service relating to such record on the behalf of another person. So intermediary basically would entail that it would include network service providers, it would include telecom service providers, it would include search engines, web hosting service providers, online auction sites, online payment sites, online marketplaces. Like online marketplaces, I'm talking about Amazon, Flipkart, even cyber cafes. So intermediaries, basically, what do? They host content, they collect information, they evaluate information, they facilitate communication, information exchange. So these are basically, I don't have to actually say what are the ISPs. So basically, intermediaries would also include your social media platforms, whether it's WhatsApp, Twitter, Instagram, Facebook. You have your e-commerce sites, your search engines, your cloud service providers. So it's just a whole gamut. So and basically, when you talk about intermediary, we also have to actually look at the facet of exemptions. So when you yourself as an individual, you are a content creator. So intermediary does not create any information but by itself, but it basically what it does is receives, stores, and transmits information. So it also has this kind of safe harbor model, which is actually there, under which the intermediaries are provided certain protection against liability for the acts of third parties. I mean, basically, who would use the infrastructure provided by committing unlawful acts, whether, let's say, for example, somebody posted a defamatory content, and somebody has actually flagged that content, and the intermediary has immediately actually acted on that and has removed that defamatory content. I don't think so they are liable for that. So under the IT Act, and post Amendment 2008, there has been a change in the definition of intermediary, and it has given a wider scope for protection to intermediaries. So basically, an exemption from liability of intermediaries. So any third-party information, data, or communication link made available or hosted shall be subject to provisions of subsection 2 and 3 of section 79. It basically, so basically section 79 talks about intermediaries function. It is limited to providing access to a communication system over which information made available by third parties is transmitted, hosted, or stored. So basically, the intermediary does not, what it does not do is it does not initiate the transmission. It doesn't, it select, or it does not select who receives the transmission, or it does not select or modify the information contained in the transmission. So, and basically the intermediary has to observe due diligence while performing its respective duties under this act. And so third party information is basically, it's basically, third party information is like basically content creators, like individuals who are accessing those social media platforms as such. So when can intermediaries be liable? So this other intermediary is guilt is it's basically if it conspires, abates, aids, or induces the commission of an unlawful act. So, and it fails to remove or disable access to any material, as I said, if anything is flagged and it does not actually, take cognizance of it, it does not remove it, or whether it's notified by the government or any individual user as such, it will be liable. So it will not get protection under the, so the new information technology intermediary guidelines and digital media ethic code has replaced the 2011 rules. So they are divided basically into three parts. It's basically talks about definitions, it talks about due diligence by intermediaries, and it talks about code of ethics and procedure and safeguards in relation to digital media. So due diligence is basically what intermediaries and the grievance redressal mechanism, which it provides for due diligence requirements to be followed by all social media intermediaries, and additional due diligence requirements to be followed by significant social media intermediaries. Significant social media intermediaries has been defined as, basically having a registered users of beyond 50 lakhs or more. And so, or any threshold which will later on actually, the central government will notify. And so basically section 2(1)(w) social media means an intermediary which primarily enables online interaction between two or more users and allows creating, uploading, sharing, disseminating, modification, or access to information using the services. So Rule 7 of the 2021 rules, they provide that failure to observe any of the rules to 2021 shall disqualify an intermediary from exemption from liability under the 79(1) of the IT Act, and such intermediary shall be punishable under the IT Act and Indian Penal Code. So publishing of the, basically, so it has, this kind of mechanism which is there. It talks about, information which will be flagged and it has to be removed. So it also talks about, basically most of the significant SMIs, which are, social media intermediaries, which are there. Appointment of, whether it shall be done within a period of 72 hours. It shall also actually talks about a grievance officer. It talks about a redressal mechanism which has to be there if it's a complaint, which is you will find, and removal of explicit content which is there. So these are the kind of which due diligence and addressing the mechanism which is there under the rules. It has to be addressed. So if you're not actually following that, there will be an issue in which you will not get the safe harbor provisions which are there in place. So all significant social media intermediaries, they require to have a chief compliance officer. It also has to have a nodal contact person. It also has to have a resident grievance officer. So and it has to also have this kind of periodic report mechanisms and compliance report in place. So and also has to actually identify the first originator of information. Now this is problematic because an active monitoring, and this is another area in which actually encryption really comes into foray. So if you could talk about the social media intermediaries like WhatsApp or Signal, there is a huge problem actually. Would when the government would flag certain messages or flag certain things, whether they would, basically water down their encryption standards and actually pass on their information. That's a huge thing, actually. Rather, we have been hearing about, the kind of mechanism which is there in place, that WhatsApp is ready to actually, leave the country, but not actually share information or compromise with their encryption standards. So this is a problem, actually, because if you water down the encryption standards and actually you part with information, there is a whole trust deficit issue which comes into foray. So this role of intermediaries has been, kind of, we have addressed that. So the next part which comes down to is securing electronic transactions. So this is another thing which comes into how do you go about, kind of digital signatures, certification authorities, electronic contracts, which we have already addressed, and secure electronic transactions guidelines, certification authorities, which prescribes rules for ensuring the security and integrity of the electronic transactions in place, encryption policies. India does not have an encryption law, so basically that is another problem which is there. It does not have, but it recommends certain standards which is there, actually, especially when it comes to digital security. We have a public key infrastructure in place, so it actually talks about encryption, talks about pretty good privacy standards which needs to be adopted. So those things are there. So the Information Technology Intermediary Rules 2011 requires intermediaries to observe certain encryption standards and practices to ensure the security and confidentiality of electronic communication. And so encryption, it plays a very crucial role in safeguarding sensitive information which are transmitted along electronic networks. So data protection policies, which we already actually we discussed, Payment and Settlement Systems 2007. So this is another actually a foray in which RBI is the central bank authority, is actually, it regulates the payment systems, including electronic funds transfer like RTGS, real-time gross settlement, or national electronic funds transfer, or card payment networks. So basically RBI issues those guidelines and regulations. So, and also it talks about RBI mandate certain two-factor authentication. It recommends certain guidelines when it comes to encryption standards, when it comes to protecting sensitive financial information. It also adheres to the entities in terms of your debit and credit cards when it comes to payment card industries data security standards, which needs so to prevent data breaches and frauds. It also actually addresses KYC norms which are there, and UPI, Unified Payment Interface, which is regulated by the National Payment Corporation of India under the guidelines of RBI. So it secures a interoperable platform for instant fund transfers between bank accounts using mobile devices. I don't need to actually do it. And the cybersecurity framework, it's Ministry of Information Technology and Computer Emergency Response Team, which is there, it serves that. And certain international cooperation standards, which we need to actually, take notice of. And anyway, so cybersecurity measures, this is not an exhaustive list, actually, but it's some of them which I could actually, we had a national cybersecurity policy. This was in 2013. So it talked about creating a secure cyber ecosystem, and it talks about strengthening the cybersecurity infrastructure in India. You have this Indian Computer Emergency Response Team, CERT. It serves as a national nodal agency for responding to cybersecurity incidents and coordinating efforts to mitigate cyber threats. It operates under the Ministry of Electronics and Information Technology, MeITY, and provides incident response, vulnerability assessment, and cybersecurity training services. You have information technology, reasonable security practices and procedures, and sensitive protection data of our Information Rules 2011, which will be replaced by the Data Protection Act 2000, Digital Data Protection Act 2023, because Digital Data Protection Act solely talks about digital data. It does not talk about analog data. And it also talks about digital data, which has been digitized later on. National Cybersecurity Cyber Coordination Center. So National Cyber Coordination Center, established under the Ministry of Home Affairs, serves as a hub for monitoring and analyzing cyber threats in real time. So it facilitates information sharing among government agency, critical infrastructure sectors, and law information enforcement agencies to enhance cybersecurity coordination and response capabilities. Also, there is a thing called Cyber Swachhta Kendra. I don't know how many of you have really visited that. Botnet cleaning and malware analysis center. They provide you certain detection software and removal tools and antivirus solutions and cyber security awareness resources. And not but the least, cybersecurity awareness programs and certain best practices which are there in place. I think so. I have covered quite a lot of actually thing. I know, I mean, it's kind of still incomplete. It's not, what do you call it? Tremendously, exhaustive. But as I told you, I mean, this is a huge, huge subject, and each and every topic is a 1 hour session. I mean, so basically, there's a lot to be covered, and maybe down the line, I mean, digital signatures or maybe cyber technology, or I mean, I'm talking about cryptography. We will address it later on. So with this, I would say that this comes to an end.
So the participant is asking, what does unless prescribed by law mean under Article 21?
Unless prescribed by law. I mean, right to privacy unless prescribed by law, because it has certain limitations. Like you can't have an absolute right to privacy. So certain things, when it comes to national security, when it comes to certain aspects, there are certain limitations to absolute privacy. So you cannot have absolute privacy. You have a right to privacy, but you cannot have an absolute right to privacy unless it is prescribed by a law. So if the law mentions that you got absolute privacy, then there is absolute privacy. But unfortunately, you don't have this kind of absolute privacy. So you have this kind of Data Protection Act, which is going to come down, Digital Data Protection Act. Up till then, the 2011 rules will be applicable. So unless and until this is prescribed by law, you cannot have absolute privacy. Okay, so right to privacy is right to life, Article 21. I think so I've addressed it. So yeah.
Okay, so the next question is,
Yeah.
why was Kotak Bank so heavily penalized by the RBI?
Why is Kotak Bank penalized? Why are most of the banks, or even for a matter of fact, last time actually it was actually we talked about. I think so. It was what was that? It's not PayPal, right? What is the we talk about which was a company which was actually it was Paytm, if I'm not mistaken. Yeah. KYC norms is a major factor which actually comes to things, and lot of compliance mechanism when it comes to banking or non-banking or payment banks. They are not very thorough in terms of compliance with those. So KYC standards, there's an absolute disregard for that. Another thing which comes down to is facets of PMLA. Another thing which comes is actually, the kind of remittance mechanisms which are there in place. So a lot of banks are not that thorough when it comes to regulations and compliance of regulations. So this is one area which comes to. I would not specifically say that because there are lots of problems with banks. RBI is a very, very late, what do you call it, as it's very difficult for RBI as a central bank, as a regulator, to really address all the issues at large. It's only actually when it really transforms into a kind of a perfect storm, they try to address those things into foray. It was not actually, they were not aware of it. A lot of onboarding systems and a lot of things, or KYC non-compliances. I mean, a lot of regulators were aware of it, especially the central bank was aware of it, but still actually they disregarded it. It's only when it snowballs into a tremendous problem that it needs addressing, and then they would come down with some drastic provision which would create a huge problem at large. So anyway, I'm not actually drawing any assumptions or presumptions with regard to this aspect, but I think so that is one of the things. So where banks, payment banks, regular banks, commercial banks, investment banks, everybody has to actually comply with regulations, especially stringent regulations, SEBI, RBI, everything. Every regulatory body, or even IRDA, for a matter of fact, they have regulations in place. So if you disregard that, you don't comply with it, you have a price to pay. So that's the only thing actually. So India is just when it comes to Indian kind of business practices, we somehow never give importance to compliances. We always give importance to rainmakers. We do not give importance to people who actually are trying to protect or mitigate a certain aspect when it comes to dealing with agencies, law enforcement agencies, or regulators as large. So I think so. I've addressed rather than actually not, delving into the aspect, because some of them are really tricky issues. If I say certain things, some of them might be clients, some of them might not be clients. So I am not at liberty to actually divulge a lot of information. So kindly excuse this kind of, yeah. So could you?
Okay, sir.
Yeah.
So the next question, I'm taking questions from the registration form. The next question. So, what are the provisions to invoke right to be forgotten in India?
Right to be forgotten in India. Unfortunately, right now you don't have any provision. The Data Provision Act, which is going to come down to, we'll be talking about it, but I really doubt actually you have this kind of thing at present, right to be forgotten. And please understand one thing, right to be forgotten at large. I mean, you are really talking about, see, having a law in place and having a technical feasibility are two different aspects. Okay. You are not only actually, you don't have a central nodal mechanism at place in which actually all the social media platforms are under one nodal aspect. You don't have a single account for all the things. You have different tech platforms, and it becomes very, very difficult actually, unless you're right to be forgotten in terms of a single media platform. Right now, GDPR has it. India does not. It does not have a framework at present. The new law has provisions regarding that, but right to be forgotten in totality would be a miracle as such, because your digital footprints are there throughout. It's going to be very, very difficult actually when you talk about right to be forgotten. Only on a particular social media platform, yes, but the technical feasibility is going to be very difficult. So you cannot really have this kind of. Please understand, having law in place and actually really addressing those regulations and you really going after them requires tremendous time and effort. Do individuals really do they have that kind of time, commitment, and effort? That's a question mark. So I think so. At present, we don't have this concept of right to be forgotten. Yes.
Okay, sir. So there's a participant raising hand, just unmuting, sir.
Yeah, sure. Please.
Yes. Good evening, sir.
Good evening.
Sir, as far as this right to be forgotten is concerned, some websites do offer facilities like, say, for example, I have my Facebook account, and if I want to, before deletion, take out all the data that I had posted. So from one particular website, it is possible, but I agree with you that technically it
that's
is
what
very.
I'm trying to say. That's what I'm exactly trying to say. It's
could
not
be replicated
possible.
on somewhere else.
Yeah, it's not possible.
Yes, and in search engine, then it's not possible. Yes. Sir, I want to ask regarding another. There is also in DPDP Act a provision for right to nomination. That is what happens to my social media accounts after my death. That is, we could nominate some person who will take care of, say, account, and who will be given the password in case of death of a person. So that will be given to all data principals in DPDP Act. That is, I think, a new feature. At present, we do not have any such nomination facility.
Right.
Yes, sir.
Yeah, but unfortunately, actually, in a country like India, if you have this kind of nomination facility, would be having tremendous regulatory backlashes. So it's a kind of
yes,
a power.
but we are going to have we are going to have Data Protection Board of India now.
Yeah, absolutely. But as I told you, any act which is not in application at present, which is a work in progress, needs to be actually, it's only 1 year down the line you will really come to know whether all the provisions and all the things are really in place and it needs to be addressed or what needs to be done. So I mean, it's still, it's a gray area. So let's not actually really delve into the thing that things are going to be gung-ho and everything's going to work fine. There will be a lot of teething issues which needs to be addressed. So anyway, they have watered down actually the Digital Data Protection Act, which was supposed to be more stringent than GDPR, but unfortunately, actually, it's not. So I mean, that's a debate in itself. So I will not actually delve into it because it has lot of leeway in which actually the state would enter into foray and actually. I mean, if they want actually, so you won't be having protection mechanism in place where the state wants it. So it's very, very, yeah.
Yeah, 2018 bill was different than 2019 and 21 bill were different, and finally this 23 Act is entirely different from that.
Yeah, absolutely.
It is just a minor criminal law. It is just a civil law. That is how it has drastically changed the nature of that act.
Absolutely.
It is even different from the Justice Balkrishna report, and even the parliamentary committee have not been considered by it. Yes.
Yeah, it's an absolute different creature. It's an absolute different creature.
Yes. So regarding this question of this Paytm, actually, I had an experience that what Paytm did was, say, if there are two transactions in two persons in every transaction, there is a say, person from whose account it is deducted, and second is the account to which it is credited. So what happened was Paytm did not have transparency. That is, if my account is say some money from my account is deducted, then I have the right to know to whom that is credited. So what it did was, the account is debited, but it didn't divulge the details even to my banker where it is credited, and that's why I was at a loss. And once I had this experience, I went to SBI and told. So they told that Paytm doesn't give us these details, and I think that's why this regulator like RBI might have come down heavily upon Paytm, because they considered only the people for whom it is collecting the money as their customers. Actually, the people from who are depositing their money, they are also customers. So they have the right to know where the account is being credited, so that if there is any fraud, they should be able to track that. So it was not there in Paytm.
Yeah, so it's a payment bank, and lot of issues with regard to actually online betting sites and all these things. It has really snowballed into a huge problem area. So payment banks, in tandem with gambling and all these things which is there online, it has created a problem. So it's as I told you, onboarding, KYC, and not having real transparency and accountability has been a huge issue with most of the payment banks. So it's not actually.
Yes.
It's only, as I said, I mean, unless and until you have a regulator which is constantly monitoring and getting into the act, it's very difficult. It's very difficult. SEBI is one institution, or IDA, which I say. I mean, these are regulators. I mean, RBI is a huge thing. It's for it to really actually go into this constant monitoring, and it's a regulation. It's a central bank which is there since I mean, it's a 20th century central bank which is operating in a 21st century digital world. So it's a very different creature altogether. So it needs I mean, a large amount of tweaking to really actually regulate payment banks and things. So it's as I said, digital transactions are a work in progress. At the most, we can do a catch-up exercise. It's not actually, it's not enough. But anyway, I mean, this all the best we can do. So at present. So I hope I've addressed your query. And
yes, thank you.
Somebody asked me about this question about intermediaries. As I said, I mean, private contracts, you see, I mean, tech players are big tech players. I mean, how do you actually have leverage over them? That's my fundamental question. You are a small player. You will have to abide by the terms and conditions. So if you don't abide by the terms and conditions, your only option is actually maybe go to Flipkart. But Flipkart is, unfortunately, it's again Walmart. So how many actually big tech platforms you will, the same problem is with actually most of the transport platforms. I mean, like, don't want to name them. Cab services, which I'm talking about. You absolutely have no leverage over them. So you have to accept the terms and conditions. So that's a problem which actually needs to be addressed, whether big tech platforms need to be reined in. That's a fundamental thing. But then again, it comes down to actually free market economics. It comes down to the thing. So it's level playing field. So these are different facets in which actually Competition Commission and things, monopolies and all these things which comes into equation. So it's not really exclusive array or foray of safeguarding digital transactions. This thing, so it will need, as I said, I mean, there are a lot of facets of digital life that needs to be addressed, and we require a session every week or every month for a matter of fact to really take this forward.
The last question.
Sure.
The law cannot catch up with technology. So what is the solution to this?
Law cannot catch up. If the law cannot catch up with the technology, there is no solution, right? We can address issues. See, I mean, it's not possible to really have this kind of mechanism where you can actually really predict what's going to transpire tomorrow. Nobody actually really devised this kind of e-commerce foray or the kind of impetus which actually e-commerce really got post-COVID. And in a country like India, where actually, digital, literacy is pretty abysmally bad. So it's a work in progress, as I said, to do anything as such to catch up. These are ethical considerations, and these are foray in which actually, it's kind of futurology, which I have absolutely no expertise in that, how we can go about it. But anyway, as I said, it's a work in progress. Maybe down the line, as things progress, as even technological wise, actually, with a lot of cloud, with a lot of maybe from binary computers we go down to actually quantum computing, things would change actually. So maybe stronger encryption, stronger things would change that. So maybe a hybrid solution is the best way to address this issue, legal issues. So it's not actually just a legal problem. It's also a technological problem. So we need to address it in a hybrid format. We don't need an exclusive kind of regulatory mechanism in place. Yeah, so
Okay, sir. Sure. Thank you so much, sir, for such an enlightening webinar. Thank you.
Thank you. Thank you very much. Thank you.